Hey guys, this is Ben from Lavocard Law. In this series of videos on contract formation, I will talk about the elements for a contract, a valid contract. Now, before we start going to the elements, I should first say that a contract can be oral. Yes, there's such a thing as oral contracts, as long as all the elements are fulfilled. Most contracts though are in writing, and there are also part oral and part written contracts. Now, what are the four elements of contract formation? The first is offer. There has to be an offer. There has to be acceptance, and there has to be intention to create legal relations, and there has to be consideration. Now I'm going to talk about the first one. What is an offer? An offer is an undertaking made by an offeror, the person making the offer, with the intention to be legally bound, by its terms, by the contract, when the other party, the offeree, accepts the terms. Next element, acceptance. Acceptance by the offeree has to be unqualified and unconditional of all the terms in the offer. He cannot change it. He cannot make a counter offer. If he makes a counter offer, then the offer expires. Next, intention to create legal relations. The parties have to have intention to be legally bound by the contractual terms, about their respective rights and obligations. Therefore, merely responding to an inquiry or request for information does not constitute offer and acceptance. For example, if you make inquiry, what is the best price you can give me for this TV? And the person replies $800. That is neither an offer or an acceptance. The fourth element for contract formation would be consideration. What is consideration? Consideration is something of value. It is a promise to do something. For example, if you buy a car from someone, you promise to pay the seller $40,000 for the car. That's $40,000 is your consideration. The seller of the car promises to sell you the car, so the car is his consideration. Sometimes it is difficult to know whether a contract has been formed because, especially during email correspondences, there's all this ding dong, and somewhere along those email correspondence, there could be an unequivocal acceptance of all the terms, accidentally, inadvertently. So when you're doing email negotiation, it is always important to put in the email subject to contract. Otherwise, you might accidentally make an unequivocal, unqualified acceptance of the terms somewhere in the email. Thanks for watching this video. There will be more videos later on going into detail on the other elements of the contract formation.